International space law, the introductions, the airspace, the outer space, key multilateral treaties, fundamental principles of international space law, free, the common heritage of mankind principle, emerging challenges in international law, COPOS and UNOSA, state practice and opinion implementations and regulations, notable cases and disputes, as well as the conclusions. The realm of international space law is a fascinating and rapidly evolving area of jurisprudence that has come increasingly relevant since the dawn of the space age. This analysis aims to provide a thorough examinations of legal frameworks governing airspace and outer space, with a particular focus on international legal regime for outer space activities. As we dive into this, we shall explore historical context, key treaties, fundamental principles, and emerging challenges in the field of space law. The genesis of outer space law. The birth of outer space law can be traced back to a pivotal movement in human history: the launch of Sputnik 1, the first artificial satellite by the Soviet Union in 1957. This technological breakthrough marked the beginning of the space age and promptly highlighted the need for a legal framework to govern activities beyond Earth's atmosphere. In the decades that followed, space technology found widespread applications in both military and civilian spheres, necessitating a robust legal structure to regulate these new frontiers of human endeavor. Recognizing the potential legal quandaries posed by these outer space activities, the United Nations General Assembly took a proactive stance in 1959 by initiating studies on the legal problems that might arise from space explorations. This laid the groundwork for the development of a body of space law over the subsequent decades. Access to and overflight through national airspace. The status of airspace has evolved significantly over the past century. In the early 20th century, even military aircraft could sometimes fly freely over foreign territories. However, limitations began to emerge through national legislation and practice, asserting territorial sovereignty and turning landing and transit facilities into negotiable commodities. The first bilateral agreement on this matter was the 1913 exchange of notes between France and Germany, which stipulated that military aircraft of one party could not fly over the territory of the other except by invitations. Civilian aircraft could fly over and land on another state's territory, subject to national regulations regarding exclusion zones. The 1919 Paris Convention was the first multilateral treaty on airspace use, recognizing that every power has complete and exclusive sovereignty over the airspace above its territory. It also accorded freedom of innocent passage to aircraft of other contracting states and allowed aircraft to cross the airspace of another state without landing. However, no contracting state could permit the flight above its territory of an aircraft without the nationality of a contracting state, except by special and temporary authorizations. Customary international law has generally not recognized the general right of overflight or landing for any type of aircraft, except where such rights were conventionally stipulated. The 1944 Chicago Conventions reaffirmed that every state has complete and exclusive sovereignty over the airspace above its territory. Over the high seas, overflights over warships and oil platforms is not generally prohibited. Different treaties have regulated overflight rights based on the differentiations between various types of aircraft, including civilian, state, and military aircraft. The regulations of flights, the general legal and institutional framework for international civil aviation is laid down in the 1944 Chicago Conventions and the rules adopted by the International Civil Aviation Organizations ICAO. The current system of exchanging lucrative traffic rights is based on bilateral treaties, where one state gives aircraft from another state the right to fly through its airspace in return for similar concessions. The air transport disputes between states are frequently decided by arbitrations. Non-scheduled flights enjoy the right of flight into and transit over the territory of a state party, which scheduled flights require permissions from the territorial state. The ICAO's proposed definitions of scheduled flights refers to flights performed with recognizable regularity according to a published timetable, in carrying cargo and passengers through airspace of more than one state and being open to public access. Since the launch of the first artificial satellite by the USSR in 1957, the use of space technology has become widespread for both military and civilian purposes. The UN General Assembly began studying the legal problems posed by outer space activities in 1959, leading to the adoptions of several major multilateral treaties governing outer space activities from 1967 to 1975. These include the 1967 Outer Space Treaty, the 1968 Rescue Agreement, the 1972 Liability Conventions, and the 1974 Registration Conventions. Additionally, the 1979 Moon Treaty was adopted. The Outer Space Treaty provides that outer space is free for explorations and use by all states and cannot be appropriated by any state. Activities in outer space must be carried out for the benefit of all countries and in accordance with international law. States must disclose information about their activities in outer space, and activities of non-governmental entities require governmental authorizations. A state which launches an object into outer space is liable for any damage caused by that object. Since 1958, the law-making process for space law has primarily relied on the work of United Nations Committee on the Peaceful Uses of Outer Space, UNCOPUOS, UNCOPUS, and its subcommittees. Customary law has developed for the essential principle of the Outer Space Treaty, which have been accepted by all states active in outer space. The 1976 Bogota Declarations by 8 equatorial countries claiming sovereign rights to segments of the geostationary orbit was met with rejections by the international community. All major treaty instruments were prepared on the basis of consensus to ensure the participation of space powers. Conflicts of interest became evident with the adoptions of the Moon Treaty of 1979, which was opposed by major space powers and accepted only by a small number of states without significant independent space capabilities. General international law does not hold states responsible for the activities of private individuals. However, in space law, Article 6 of the Outer Space Treaty establishes that states bear international responsibility for national activities in outer space, including those carried out by non-governmental entities. The 1972 Liability Conventions provides for absolute liability of states for damage caused by space object on the surface of the Earth or to aircraft in flight. The technical necessities of jointly using resources and the immense financial and technological requirements of conducting activities in outer space necessitate international cooperations. Regulatory needs, most obvious in satellite communications and remote sensing. The development of space law was accompanied by innovations in international organizations concerned with the explorations and use of outer space, such as the European Space Agency (ESA) and the International Telecommunications Union (the ITU). The Treaty on Principles Governing the Activities of States in the Explorations and Use of Outer Space, including the Moon and other celestial bodies, commonly known as the Outer Space Treaty, is the primary instrument of international space law. It is adopted in 1967. This treaty establishes the fundamental principles that guide all space activities. Its key provisions include freedom of explorations and use. The treaty enshrines the principle that outer space is free for explorations and use by all states. This provision ensures that no single nation can claim exclusive rights to space explorations. And also non-appropriations, as provided under Article 2. It prohibits national appropriations of outer space, including the moon and other celestial bodies. This principle prevents any state from claiming sovereignty over celestial bodies or portions of outer space. And the benefit and interests of all countries. This treaty stipulates that the explorations and use of outer space must be carried out for the benefit and interests of all countries, regardless of their degree of economic or scientific development. It mandates that activities in outer space must be conducted in accordance with international law, including the United Nations Charter, thereby extending terrestrial legal norms to space activities. The treaty requires states to avoid harmful contaminations of outer space, the moon, and other celestial bodies, as well as adverse changes to the Earth environment resulting from the introductions of extraterrestrial matter. States must also conduct their activities in outer space with due regard to the corresponding interests of other states, avoiding interference with the activities of other states in the peaceful explorations and use of outer space. The treaty promotes transparency by requiring states to disclose information about their activities in outer space and to allow observation of space flights by other states. The states bear international responsibility for national activities in outer space, including those carried out by non-governmental entities. The treaty also prohibits the placement of nuclear weapons or other weapons of mass destruction in orbit around the Earth, on celestial bodies, or in outer space generally. It also limits the use of the moon and other celestial bodies only for peaceful purposes. This agreement on the rescue of astronauts, the return of astronauts, and the return of objects launched into outer space, commonly referred to as the Rescue Agreement, 1968. This treaty elaborates on Articles 5 and 8 of the Outer Space Treaty, focusing on the humanitarian aspects of space explorations. Its key provisions include assistance to astronauts in distress. State parties are obligated to take all possible steps to rescue and assist astronauts in distress and promptly return them to the launching state. The agreement requires state parties to return space objects found in the territory to the launching authority. These conventions on international liability for damage caused by space objects, or known as liability conventions, was adopted in 1972. This treaty expands on Article 7 of the Outer Space Treaty, providing a more detailed regime for liability in space activities. Its main provisions include absolute liability, in which the launching state is absolutely liable for damage caused by its space objects on the surface of the Earth or to aircraft in flight. Also, the fault-based liability, in which the damage caused elsewhere than on the surface of the Earth to a space object of one launching state, or the persons or property on board such a space object by a space object of another launching state. The latter is liable only if the damage is due to its fault, or the fault of persons for whom it is responsible. And also joint and several liability. When two or more states jointly launch a space object, they are jointly and severally liable for any damage caused. And the claim procedures. The convention establishes procedures for the presentations and settlement of claims for damages. These conventions on the registration of objects launched into outer space, or the registration conventions. It was adopted in 1975. This treaty aims to create a centralized system for registering objects launched into outer space. Its key provisions include national registry. Each state party is required to establish a national registry of objects it launches into the outer space. The United Nations Register. The United Nations Secretary General is mandated to maintain a register of objects launched into outer space containing information furnished by state parties. Registration information, in which state must provide specific information about each space object, including the name of launching states, designator or registration number, date and territory of launch, basic orbital parameters, and general functions of the space object. This agreement, governing the activities of states on the Moon and other celestial bodies, commonly known as the Moon Agreement, was adopted in 1979. Although it has not been widely ratified, it remains a part of the corpus of international space law. Its key provisions include peaceful purposes. The agreement reaffirms and elaborates on the peaceful purposes principle established in the Outer Space Treaty, specifically applying it to the Moon and other celestial bodies in the solar system. Common heritage of mankind. It introduces the concept of the Moon and its natural resources as the common heritage of mankind, a principle that has been the subject of debate and interpretations. Freedom of scientific investigations. The agreement guarantees the freedom of scientific investigations on the Moon and other celestial bodies. Environmental protections. It includes provisions for protecting the lunar environment and for sharing scientific results, and also a future regime for resource exploitations, in which the agreement calls for the establishment of an international regime to govern the exploitation of lunar resources when such exploitations becomes feasible. The freedom of explorations and use, as enshrined in Article 1 of the Outer Space Treaty, it guarantees that outer space, including the Moon and other celestial bodies, is free for explorations and use by all states without discriminations. This freedom, however, is not absolute and must be exercised in accordance with international law and with due regard for the interests of other states. The non-appropriations, as provided under Article 2 of the Outer Space Treaty, it prohibits national appropriations of outer space, including the Moon and other celestial bodies, by claim of sovereignty, by means of use or occupations, or by any other means. This principle is fundamental to the concept of outer space as a global commons. Peaceful purposes. The use of outer space for peaceful purposes is a cornerstone of space law. While the exact interpretations of peaceful purposes has been debated, it is generally understood to prohibit aggressive military activities in space while allowing for non-aggressive military uses such as reconnaissance satellites. International cooperations, the Outer Space Treaty, and subsequent agreements emphasize the importance of international cooperations in space activities. This principle encourages states to collaborate in scientific research and to share the benefit of space explorations. State responsibility and liability. States bear international responsibility for national activities in outer space, including those carried out by non-governmental entities. This principle, as established in Article 6 of the Outer Space Treaty, it further elaborated in the Liability Conventions, which provides for the absolute liability of states for damage caused by their space objects. And the environmental protection. The protection of the space environment is a key principle of space law. Under Article 9 of the Outer Space Treaty, it requires states to avoid harmful contaminations of outer space and adverse changes in the Earth environment resulting from the introductions of extraterrestrial matter. The common heritage of mankind principle has been a point of contentions in the development of outer space law. While the Outer Space Treaty uses the terminology of the common province of all mankind, in Article 1, the Moon Agreement more explicitly refers to the common heritage of mankind principle in Article 11. The legal implications and customary law status of the common heritage of mankind principle in the context of outer space are not entirely settled. Some scholars argue that it encompasses only the prohibition of national appropriations, while others suggest that it also has regulatory implications for the exploitations of space resources, even in the absence of multilateral regime. The relevance of the common heritage of mankind principle is likely to become more pronounced as the potential for commercial exploitations of space resources increases in the future. This raises complex questions about the equitable sharing of benefits derived from space resources and the balance between encouraging space explorations and preserving space as global commons. As space technology advances and new actors enter the field, international space law faces several challenges. One of them is space debris. The increasing amount of space debris in Earth orbit poses significant risks to operational satellites and spacecraft. While guidelines for debris mitigation exist, there is growing need for more binding legal instruments to address this issue. Commercial space activities, the rise of private companies in space explorations and exploitation raises questions about the application of existing space law, which was primarily designed with state actors in mind. Issues such as property rights in space, liability for private space activities, and the regulations of space tourism require careful legal considerations. Militarizations of space. While the Outer Space Treaty prohibits the placement of weapons of mass destructions in space, it does not explicitly ban all military activities. The development of anti-satellite weapons and the potential for space-based missile defense systems raise concerns about the militarizations of space. Small satellites and mega constellations. The proliferations of small satellites and plans for large constellations of satellites pose challenges. for space traffic management and raised questions about equitable access to orbital slots and radio frequencies. The long-term sustainability of space activity requires addressing issues such as space debris mitigations, space traffic management, and the protection of the space environment. The space resource exploitations, the potential for mining asteroids and other celestial bodies for valuable resources has sparked debates about the legality and regulation of such activities under existing space law. The United Nations, particularly through its Committee on the Peaceful Uses of Outer Space, COPUS, has played a crucial role in the development of international space law. Corpus, established in 1959, has been instrumental in drafting the major space treaties and continues to work on developing guidelines and principles for space activities. The United Nations Office for Outer Space Affairs, UNOSA, serves as the secretariat for Corpus and plays a key role in promoting international cooperations in the peaceful uses of outer space and the applications of space technology for sustainable development. While the treaty regime forms the core of international space law, customary international law also plays a significant role. State practice and opinion jury have contributed to the development of customary norms in areas such as the non-appropriation principle and the use of geostationary orbit. The interactions between treaty law and customary international law in the space domain is complex, particularly as new challenges emerge that were not envisioned when the core space treaties were drafted. As space activities increasingly involve non-governmental actors such as SpaceX, many states have enacted national space legislation to implement their international obligations and regulate private space activities. These national laws address issues such as licensing of space activities, liability and insurance requirements, and environmental protections. The development of national space laws contributes to the overall body of space law and helps to clarify the interpretations and applications of international space law principle in specific contexts. While there have been relatively few court cases directly addressing space law issues, some notable cases have contributed to the interpretations and applications of space law principles. Nemes versus United States in 2004. In this case, although dismissed by the US courts, raised questions about private property claims on celestial bodies. Satellite disputes before the International Telecommunications Union (ITU) were not strictly court cases. Disputes over satellite orbital slots and radio frequencies have been addressed through the ITU's dispute resolutions mechanisms. Cases before national courts involve satellite communications and remote sensing have also contributed to the interpretation of space law principles in specific contexts. International space law has evolved significantly since the launch of Sputnik 1, developing into a comprehensive framework of multilateral treaties complemented by the customary international law principles. The United Nations Committee on the Peaceful Uses of Outer Space has played a central role in this process, facilitating cooperations and the progressive development of space law. As space technology and activities continue to advance, the international community faces new challenges in maintaining the delicate balance between national interests and the common interests of humanity.